A pleasure to be able to speak on this bill, in support of this bill, and I recognise how many deputies speak in support of this amending legislation today. It is a very necessary fix for what was a real wrong, and the scenes that we saw in Dublin and elsewhere were deeply wrong and very difficult and shouldn't have happened. The enforcement of court orders generally, whether it's the enforcement of court orders in relation to property or whether it's the enforcement of court orders in relation to maintenance and access and family law, enforcement of court orders in domestic violence, it's a continual problem. I note that as a House we spend more time dealing with the enforcement of court orders on property than we do with the enforcement of court orders, say for example in relation to domestic violence, but we can come back to that, I can come back to that perhaps later. But we do have to recognise that where there is a court order recovering property, that it be done with dignity. The court process is difficult enough itself, and I know from experience the efforts the courts make to try to facilitate and help lay litigants, but it is a difficult process for anybody going there for anything. It is a stressful and difficult process, and that's particularly the case when it's the family home in particular. So if there is an eviction, if there is an enforcement of court order, it must be done with dignity. It must be done with dignity for the person's dignity, for the property owner's dignity. It must be done with dignity from the perspective of the court and from the perspective of the state. And we have seen in large part the sheriff system be able to do that, and we have as a state allowed and regulated for and indeed legislated for not a third force but another system to work in parallel with that, and we're clearing up and clarifying some of that today, and that's important. But I think that I've been listening to the debate very carefully, and a lot of speakers have referenced the fact that, well, of course, people who won't pay, we have to enforce those orders. But there isn't really a follow-up on that from speakers that I'm hearing. If we accept the premise that, there are people who refuse to engage, refuse to pay, and that those orders must be paid, then we do need to talk about how that is done. It's a pretty reasonable response. There are people up and down this country who are paying their mortgages every month and have been doing so for many years, and who are privileged to do so, privileged to own their homes and to pay their mortgages and to have their family homes. But it makes what is the point for them of continuing to do that if they don't see that there is while they want to do it, if there isn't a read across for people who refuse to do it, not those who are in difficulties and can't do it, and again I'll come back to that, but we have to accept that it's necessary to pay debts, and that if you can't do it, then the state already has structures to try to help with that. If you won't do it, then we do have to talk about how that's enforced. And I was just listening to Deputy Collins in relation to the amendments there that they're going to bring, that you're proposing, for example, about only having evictions between 12 p.m. and 5 p.m. And I'm interested, to hear the rationale for that at committee stage. What's the difference between, why not business hours? Why, in particular, if the concern is around children, why not between 9 and 3? Why, the provisions around notice for evictions are so important. But I'm really interested to hear, the rationale for some of those, and the practicality for some of those. But the reality is the Irish state at the moment, the central bank published a report today which shows that we have the highest mortgage rates in Europe. And we have that in part because of the lack of competition. And we have lack of competition in part because of a difficulty with enforcing court orders over the last 10 years. And that's partly because people can't pay, and we didn't have the structures to help them, we do now. And it's because people won't pay. But the effect of that, of people trying to get mortgages under the new macroprudential rules, which are already very difficult for people with 10% and 3.5 times income, makes it more difficult to get a mortgage, makes it more difficult to continue to pay a mortgage because of these comparatively high interest rates. And that lack of competition is a bad thing for every homeowner in this state, for every person with a bank account in this state, for every small business, for every big business, for everybody who wants a functional banking system. A lack of competition is a problem. And we, deputies who talked about a public banking system, I think there's something really there. Deputies in my party have discussed that, are interested in that, the expansion of the credit union scheme. There are a whole range of different ways of achieving competition. But we have to recognise the part that being able to recover assets, whether that's not paying a car loan or not paying a mortgage, the implication, the impact of all of that on the banking system and on being able to have a banking system that we can all access and use. I'm sorry, I've lost my point. Going back to the point in relation to the enforcement of court orders generally, the enforcement of court the enforcement of domestic violence orders, we don't have a similar structure in relation to this. We have an ad hoc system where the Gardaí are sort of dependent on having the order, having access to it, and it doesn't work in the same way. I flag this only, Minister, because of the amount of time that we spend on this. We have the capacity to enforce civil debt and fines, but not necessarily maintenance payments in family law situations. I just want to flag it as a sort of a contrast in terms of how we treat orders generally from the courts. There's no difference in terms of seriousness between the enforcement of a family maintenance order and the enforcement of a property order, except that one is a tangible, pointable asset that can be recovered via this system. That's fine. Going back to Deputy Healy-Rae's point about having systems for people who can't pay. I'm conscious, of the development of the mortgage to rent scheme that is there and has been there for some years. But what I would say is, I have a couple of people in my constituency who are trying to transition to that now, and the experience of dealing with a fund that has bought the loan from a bank who has now left the market. The fund has bought it, and it has been difficult to deal with the fund. It has been difficult for them to access them, to get a number, to get a call back. If they don't answer the phone, immediately it's, well, you didn't answer, you're not engaging, all of which isn't really true. It's just that it's very, very difficult. The actual difficulty arose with the previous bank, but because it's left the market now, it's impossible to recover and go back through the records of that to identify where the real problems were, where the charges were, and to have a real measure of accountability. The mortgage to rent process has been working reasonably well, and it does offer a security, but it's such a painful option for people to have to take, where they have had difficulty over time and where they have felt that that difficulty really hasn't been recognised. Thinking of one lady in particular who had cancer treatment at an early point in her mortgage within the last 10 years, which made a material effect on her ability to pay. That's when it needed to be sorted out, not 6 and 7 years later when it just became too late. But at least we have the mortgage to rent system now, and I've run out of time, so thanks very much, Ciarán.